So, hello, my name is Victoria. I'm one of the estate planning attorneys with the Kopenbarger Law Firm, and today I am joined by my husband, Zachary Rayman, as we talk about different protection options of how can you really protect those you care about the most, whether that's yourself, your family, your friends, your pets, your charities. What is it that matters most to you when you're thinking about protection and who you want that applied to? So with estate planning, we're going to talk about what can the estate planning side do? What can it do when you're no longer here? What can it do if you're incapacitated? And how do you make sure, especially once you're gone, again, those people you want protected really do have that around them? Then Zachary's going to talk more about the financial side of things. So finances, again, play a huge role with estate planning, but they are something that needs to be treated separately. And so it's important that you work with a comprehensive team where they can go through both sides. I do want to emphasize that this webinar is for educational purposes only. So today we're going to go through more general information. If you do have specific questions that we're not able to answer on the spot, please feel free to take advantage of a consultation with either Zachary or myself. Now, if you don't know Kopenbarger or it's been a while since, oh, I apologize. I was told that there's an echo. If anyone else is having that issue, please flag it. But for those of you who do not know Kopenbarger, or it's been a while since you've seen us, I do want to quickly highlight that not only do we do estate planning, we also do a number of other things. We have a business and tax department where if you have a business, if you have a rental property, if you are looking into additional protection options, we're able to assist you in more advanced planning arenas. If you are someone who is serving as a trustee, so you've lost someone and now it's your responsibility to administer that person's estate, or after you've passed away, your loved one would be responsible, we have our estate administration team. And then most of what we talk about is how not to wind up in court. But we do understand, unfortunately, that things do happen. And so if court becomes necessary, we have our litigation attorney who is fantastic and is able to step in and help either assist you or your family if things do come up. And then we could not do what we do without our incredible staff. So when you work with an attorney at Kopenbarger, you often are also working with a team of staff to help make sure that things run smoothly and that your questions can be answered as quickly as possible. And then we have offices all over the state. Now, everywhere that we are, Lifestyle Financial is also. But we, for both companies, are able to serve the entire state of California. And so if you are not in one of these physical location areas, don't worry, we can still either do phone calls, Zoom, or if you're comfortable driving, meet you in person. So let's start with the estate planning side. So why is estate planning so important? Well, your plan is there to speak when you no longer can. One of the big issues we see is when people do not plan and they just assume that things will go how they hope they would go. Unfortunately, when life takes a turn without a plan, they don't have anyone who completely knows what their intent would have been. So the goal with your plan is to step in when you no longer can communicate, whether that's because you're incapacitated or because you've passed away. A lot of people just think about estate planning from the I've passed away perspective and where is my estate going to go? But a lot of people forget what happens if I'm alive but I'm unwell. I'm in the middle of a surgery and I need someone to make a decision for me. I can't pay my bills anymore because I've had a stroke and I'm no longer able to sign checks or fully communicate. Things that happen that we hope to avoid, but know that unfortunately with life are a reality can be helped when you have a plan in place. And the estate planning side, again, is there to step in and communicate when you no longer are able to. And when we're talking about estate planning, we're talking about a very comprehensive set of documents. If you're watching today and you do not have any estate planning or maybe a limited estate plan, this next section is going to help highlight what is it that you actually need in place and why. If you do already have the documents in place, I also want to emphasize it's very important to take those out and review them every so often. We recommend to all of our clients that they come in every 3 to 5 years. The reason being we don't necessarily expect things are changing all the time, But if life changes or the law changes in a way that your estate plan needs to account for, we want to make sure that that gets done before a problem comes up. So the first one to make sure you have in place is an advanced healthcare directive. The Advanced Healthcare Directive is there to communicate medical decisions on your behalf when you no longer can. And it's also there to make sure that the person you want to make those decisions is actually given the proper authority. So, one thing a lot of people don't realize is even your spouse does not have an automatic right to make your medical decisions. So, if I, for example, was rushed into the hospital, I was in a car accident, I've been taken into the hospital. Zach knows that I've been taken to the hospital, but he's not physically with me. So, he's racing down to try to meet me, and he doesn't have my healthcare directive. Legally, they are not even allowed to tell him what room of the hospital I am in. But if he has this directive that I've set up that says he has that authority, now he shows up and they just know, yes, he is the person I want in place. So again, no one has an automatic right. So if you do not have a healthcare directive at all, it is imperative that you get one started today. If you do have a healthcare directive, you need to make sure it has been done since 2004. Any that are older than 2004 are no longer valid. So if you have a directive, you need to double check that date. But you also, again, want to take a peek at this thing every few years, because the reality is the person named in this document is going to be making decisions when you're in a fairly vulnerable state because you can't communicate anymore. And so making sure the right people are in that document is equally as important. Because again, you're putting a lot of trust and faith into someone, and we want to make sure it's still the right person. The next document you need to have in place is a durable or financial power of attorney. So this is the document where if you're no longer capable of managing your money, it's giving somebody the authority to do so on your behalf. Now, with this document, even if you are married and your spouse is on some of your accounts, it's still imperative that you have a document in place. Because for accounts like retirement, your spouse is not named as a co-owner. They're often named only as a beneficiary, which means without a power of attorney giving them authority to manage the account if you are incapacitated, they are not legally allowed to even manage for you, which can mean that that money can sit there unused until you pass away. So having a power of attorney, whether you're married or not, is extremely important. And then for anyone beyond a spouse, in most cases, they really aren't going to have any authority without you putting it in writing. Now, I mentioned with the healthcare directive, it needed to have been done since 2004. With your durable or financial power of attorney, it needs to have been done in the last 5 years. If the financial power of attorney is older than 5 years old, banks have started rejecting them because they are being considered stale. Essentially, they are too out of date for the bank to rely on that document alone for the person to have full authority on different accounts. So it is extremely important that for this one, you again double check that date and see, was it done in the last 5 years? If you're not sure or you know it was older than 5 years, come and see us and we can either double check or get you a new one to be active and have the full authority in place. The next question is, do you need a will or do you need a trust? So if you have minor children, you need a will. So Zach and I do have a minor child, so we absolutely need a will because that is where guardians get named. That is, if God forbid something happened to both of us, our daughter is still going to then be able to go to the people we would want. If you have minors and you don't put guardian designations in place and something happens to both parents, the court gets to step in and the child may become a ward of the state temporarily. And then the court gets to decide who that child goes to. So again, if you have any minors, it is imperative that you get a will in place. Then we're going to look at, do you only need a will or do you also need a trust? So if you have less than $200 and just shy of $9,000, or you have no pieces of real property, a will may be enough to satisfy what the court is going to be looking at when it comes to your estate. If you have more than $209,000 or you own a piece of property, A will is not going to be the only document you would need. We would need to start talking about trusts. And the reason that we need to talk about trusts is if you only have a will, but your estate is greater than what the will protect, the probate court gets to step in after you have passed away. What that essentially means is the court is saying that you had too simple of a document for too complex of an estate. And because of that, they now get to step in and decide what happens. They get to decide who is going to settle things on your behalf. They get to decide who is going to actually inherit and how. And again, if you have minor children and didn't put guardians in place, they get to decide ultimately where those kids are going to go. So it puts way too much control in someone else's hands and in someone's hands who does not know you and does not know what matters most to you. So we really want to, again, talk about trusts. A trust is there to answer all of the questions that the court said a will did not. So it will dictate who is going to manage if you no longer can. It is going to dictate who is going to inherit and when. So let's again go back to minor children. Just because a child turns 18 does not necessarily mean that they are mature enough to manage an inheritance if you passed away while they were still relatively young. And so you get to set when would that child actually receive money. It could be used for them before they hit that age period, but when would you be comfortable handing them the keys to the car, so to speak? And again, for a lot of people, 18 is not that age. But your trust gives you the flexibility, control, and power to set up everything that you want. Again, who's going to manage, who's going to inherit, what's going to happen when you can't communicate your wishes any longer. So you have that control. You get to keep communicating even after you've lost the physical ability to do so. So not only does your trust allow you to avoid the court and protect your privacy, it also allows for some additional tax planning. So when we're talking about taxes, this is not just what's applicable to the 1% of wealthy people. This is, what about property taxes? Will they be reassessed when I die and things transfer to my kids? What about capital gains taxes? What's the advantage or disadvantage to transferring something during life versus waiting for when I pass away? For some, it's income taxes. Again, we have our business and tax department. Maybe it's business taxes. There are so many different taxes that apply to us, whether we like it or not. But one of the things your estate plan allows you to do is avoid unnecessary taxes, or at least reduce unnecessary taxes. Because why would you want to pay a penny more than is legally required of you or your estate? So your estate plan, and with a proper financial plan, can again help keep money in your pocket during life, but also help preserve the money for the legacy you want to leave for those you are looking to protect. But one of the limitations of a trust is that when you set it up, it needs to actually hold title to certain accounts. Generally speaking, the title applies to checking and savings accounts, non-retirement investment accounts, and pieces of real property. Working with a financial advisor who understands how titling works and how vastly important it is a crucial component to making sure your estate stays out of court after you die. So what does this in practical terms look like? If you worked with Kopenbarger, you should have been instructed that after your signing, you should take what is called your certificate of trust to your bank or to your financial advisor and let them know that you have a trust and provide that certificate. At that point, the accounts will be titled in the name of your trust, which is the final step to ensuring the court never gets a say in what goes on after you've passed away. But we understand life happens. People forget to do this. Years go by and they acquire something new and they haven't talked to us in a while and they just forget to do that step. And time goes on, they ultimately pass away, and that account was in their name alone. Ordinarily, that account would still need to go through the court. But we have created with Kopenbarger Trusts what is called a pour-over will. What that essentially means is it's telling the court that, hey, I missed a step. I forgot to go to the bank, my bad, but my intent, as identified in the will, is that everything should go back to my trust, that ultimately the trust, not the court, should control what's going to happen to that asset. So we have this safety net created. but it's not an ideal. So if you're not sure if you've properly titled your assets, feel free to come speak with us. Or if you're not sure if your advisor understands, you can set up a consultation with Zachary to do a double check of some of those things. If you either have an advisor you're not sure about, or you may not have an advisor, period. Now, a lot of what we talk about is the money side of things, but what about your stuff? So, especially when we're talking about how to protect those that you care about, stuff is an often overlooked component. But the stuff is a lot of times what unfortunately can wind up causing fights after you are gone, because the stuff is what has often an emotional value attached. Now, a lot of people will say, my kids don't want anything. They don't seem that emotionally attached to any of my items. And what we will always push back on is a lot of times that is very true because you are still here. Now, some people don't have that sentimental side of them, and hey, that's fine. But for a lot of people, once the loved one is gone, that's when all of a sudden the stuff becomes extremely valuable to them from the emotional side. And unfortunately, if one item becomes emotionally valuable to multiple people, that can cause fights. So, one of the things in the Kopenberger Trust that we have set up is the ability to use what is called a letter of instruction or a memorandum. Essentially, what that means is you can designate in handwriting what an item is, who it's going to go to, and you just sign and date it. Now, it has to be in your handwriting to avoid needing a witness or a notary. But if you decide to type it, just get a witness or a notary who says, yes, you're the person who typed it and signed it. But by designating items, it can help cut out those fights because you're saying, hey, my child A is going to get this ring, child B, you're going to get this necklace, and child C, you're getting a bracelet. That way, they all get an item, but they're not fighting over the same thing. So, using those letters, putting that in writing can help again protect the family on the emotional side, even after you are gone. Apologize. I'm going to peek at a quick question. I'm not 100% sure on the question, so I'll try to answer that and get more information at the end. So, what about your digital assets? So, most of us have a digital account walking around with us in our pocket every day. But what happens to the things on our phone when we pass away? Who has access to our photos? Who has access to our contacts? Who has access to the drive that we have? Well, that can be really dependent on, does the person that you want to have it have your password? If they don't, it is important that you set up what are called legacy contacts. Now, for iPhone users, it's extremely easy to set up a legacy contact. You can often just Google set up legacy contact and there's step-by-step instructions. For Google and Samsung users, it's a little more complicated, but again, you can look it up of what those steps are. But the legacy contact is essentially who, if they don't have a password, is allowed access to your phone or your account after you are gone. Most of us don't have printed photos anymore. A lot of us, again, keep them on the phone. Most of us don't have a Rolodex or a contact book anymore. We keep them on the phone. And so after a loved one passes away, a lot of that emotional value that would have been captured in your phone gets lost if someone doesn't have the ability to access it when you are gone. So if you have any questions on how to make sure that that value is not lost, again, feel free to come and speak with us. We're happy to help walk you through. So what happens as life changes? So I mentioned that we recommend clients come and see us every 3 to 5 years because we understand that life does change and your estate plan likely is not going to look the same after 20, 30, or 40 years. Maybe you were unmarried when you first saw us and now you're married. Maybe you had no children or little kids and now they're grown and they need their own protection. Maybe it's that you've moved or you now have aging parents. There's a variety of different reasons that as life is changing, your estate plan needs to look different. Again, children growing up is one of the key components because the protections you had for them when they were little may not be the same protections that they need now that they're 30 or 40 years old and have kids of their own. So, as these things come up, we recommend come in and see us. We can help walk through okay, what did your plan say then? Does it still match your intent and goals and wishes today? Are there other protection options we need to put in place? What is the scope today versus what was it 10, 20, or 30 years ago? With life changes, again, I mentioned that there's additional protections that we can look at. So, especially when you have minors that are now adults. For adult children, it often means they have their own potential liability and risks. So, what happens if they're married and get divorced? How do you preserve the inheritance? What if they have their own business and that business goes under? How do you make sure that any sort of bankruptcy or tax issue doesn't affect the inheritance you've left? What if, unfortunately, we live in a litigious society and someone sees they've received a huge chunk of inheritance and now wants to sue them for something arbitrary? How do we protect that inheritance? There are things that can be put in place as kids get older to help make sure that the inheritance is not subject to outside predators. What happens if your wealth has grown significantly and you want to make sure that, well, yes, I want my kids to inherit, I want them to continue being good stewards of this wealth. I don't want them to just inherit and be frivolous and wasteful. How can I set up charitable giving intent? How can I make sure they continue the legacy that I have established? And I mentioned at the very beginning that we have our business and tax department where we do significant advanced planning. So for some people, the revocable trust and the documents I just talked about, that's really all that they're going to be looking at needing. But for a lot of people, it's going to go beyond that. I know for Zach and myself, we have quite a farm worth of animals at this point, but they are family to us. So, how do we make sure that if something happened to both of us, not only is our child protected, but any animals that we have continue to receive the care that we want them to have? What if I have a special needs child? How do I ensure that while they still receive an inheritance, they don't lose government benefits that are vital to taking care of them? I now have grandchildren and I want to set up an education trust for them and make sure that their education can be at least partially covered. What if I have a blended family and I'm remarried? How do I make sure that the wealth I built for my kids will still be preserved for them? There are a lot of different things that go beyond the basic revocable plan. And we're able to touch on those to make sure, again, the protections that you're really looking for and need get put in place. I mentioned special needs trusts. This is an area that a lot of people are unfamiliar with. What a special needs trust is designed to do is to allow you to still leave an inheritance for someone who's on government benefits because they have an advanced care need. But if you leave an inheritance to somebody outright, it can trigger a loss of those benefits. And a lot of times, the inheritance that's being left is very, very generous, but it's not enough to completely cover the person's needs, especially not long term. And so we don't want to cost them those benefits. And so we set up a very protective trust that allows the money to supplement what the government does not cover. That way, again, they can receive an inheritance, but they're not losing those benefits. If that is applicable to you or you have more questions, we have done a specific webinar on this topic, but we also are happy to meet with you directly to help answer any questions about this. I mentioned adult children. So we are able to set up what are called generation skip trusts or lifetime protective trusts. Now, don't let the name scare you. It does not mean that we're skipping your children. It's just a form of trust that allows you to preserve an inheritance so that, especially when your kids pass, it can continue down the generational line instead of going somewhere you may not have wanted it to. But these are the protections from divorce, lawsuits, creditors, bankruptcy, and the IRS. It's that added protection so that financial predators don't get to touch your child's inheritance. I mentioned minors, and that just because someone turns 18 doesn't necessarily mean they are mature enough to now manage an inheritance. So we often, for minor children, set up what are called minors' trusts. that say, hey, maybe 18 is too young. Let's say at 25, once maybe you're out of college or you've had a job or trade school, you're starting to figure out that life is expensive and you're hopefully getting a bit more mature. I'm comfortable with you getting it at 25. Or for some people, it's 30, maybe it's even 40, but you get to decide when you think the child will be mature enough to actually physically have the money for their own inheritance purposes and their own use. But again, the money can be used on their behalf by the person you set as the trustee. So your trustee can use it for their education, their health, their living, their development needs, so that the money is still for their benefit, but again, not directly controlled. I mentioned pets. So, again, if pets are part of your family, make sure they are provided for. One of the things that is absolutely devastating for me, at least, is that after someone passes, if a pet is not provided for, whether that's who they go to, whether that's money being left for their care, specific instructions, if that is left blank, a lot of animals wind up going to the shelter after someone passes. Because sometimes a child is allergic, or maybe they live somewhere that they cannot take on a pet. Maybe they already have pets of their own. Maybe people just don't really like the animal. I don't understand that last point as much, but it is absolutely part of it. And so, if you do have pets, please make sure to at least mention them if you're concerned at all about who would be able to take them. What if you want to do charitable planning? Now, for some people, they do charitable planning because charitable giving has significant tax benefits both during life and after you've passed away. But for some people, it's also that, hey, during my life, I gave to an organization. I want to make sure something goes after I've passed. So, your estate plan or your financial plan can also help accommodate for different levels of charitable giving. So, especially if you're concerned about taxes and tax benefits, that's where we're going to talk a little bit more advanced about specific types of charitable trusts. But for many of my clients, it's simply mentioning an organization or multiple organizations in the revocable trust that they have. But especially when it comes to charitable giving, we see this intent change quite often. And so, again, it's important to pull your document out every so often and make sure that the charities you initially named and the amounts you initially were giving still make sense for where you're at today. But I really do want to highlight that as life goes on, again, we understand your estate plan may change, but emailing us what those changes you want would be is not enough to make them formal. Writing all over your document is extremely risky because you may actually invalidate the document or at a minimum lead to confusion that can wind up in court. So if you do have changes you know about, before you start trying to do it at home or email us and think that that's enough, please do set up a consultation so that we can make sure things are done correctly so that there's not confusion and there aren't things that would go wrong after you have passed away. So that is it for my section at this point. I am now going to hand it over to my husband, Zachary, who's going to talk about the financial side of things. As I mentioned, estate planning and financial go hand in hand. And a lot of what we talk to our clients about really does only get better and more benefit by working with an advisor who understands the importance of titling assets and trust planning. Lifestyle has been around since 1995 and was actually founded by our founder's wife. So Lifestyle and Kopenbarger have been working together for quite a while and really want to make sure that families get protected. With that, I'm going to turn it over to Zachary.
Thank you, Victoria, and hello, everyone. My name is Zachary Rayman. I'm one of the primary advisors at Lifestyle Financial. We have had a wonderful multi-decade relationship with the law firm Kopenbarger and Kopenbarger. And really, as Victoria said, or Vicky, as I like to call her, we talk about being a steward of wealth. That may change over time, and we'll spend a few minutes talking about what that might mean to everyone. Every story is unique, every situation is unique, but it requires, as you have seen, careful planning with the right trusted attorneys and counsel, and then the right team to implement that plan. And as we go through a few vocabulary words or a few situations or a few things to take away from this, I want you to think that the investment landscape is constantly a changing field. And so you want a team that not only understands all the hard work that you've done to create the four walls of your estate plan, but also implement the moving parts or the financial components that go into this estate plan so it can actually do the things that you want it to do. And as you've seen, for decades, we've been around and we constantly try to be a student and understand and educate those we work with for your benefit, as well as our own, because this landscape never stops changing. So we're going to cover a few things regarding the investments in your estate plan, a little recap, and how, as everybody who attends this webinar will be able to have access to a free financial consultation with Lifestyle Financial afterwards, how we can help if we're the right fit, or if you just want a simple second set of eyes, if you already have a financial plan, use us as a gut check. We are here to help. We've been around. We're celebrating our 31st year. The way I like to explain this to people is if it touches money, anything more than $5 or even $4.95, accounting for inflation, we can be of service. We can help advise on it. Few of the biggest vocabulary words that we want to talk about today is diversification. What is diversification? It's not the same as all eggs in one basket. It's not even looking at one investment here versus another investment. It is making sure that you're able to navigate all of the complexities that life bring up as you get older, as you start a family, as you buy a house, as you plan for grandchildren. Maybe you have a investment property. Maybe you run a business and are looking for a succession plan. All that has a financial component and you want to be diversified to handle all of these different life events. And ideally, as we like to work with generations, which is the greatest gift in financial plans to help families from one generation to another make the best informed decisions from every aspect of their financial affairs, we generally end up talking to one generation to the next and so on. We live up here, my wife and I, in Silicon Valley. There's a lot of concentration in tech companies. Concentration risk is simply being overly focused in any one area of the investment landscape. I also like to explain this to people that maybe you're too much focused on, I need to own a bunch of real estate. Yes, we'll talk about real estate as well. Or I only want to buy things in an IRA or a 401k. These are useful tools. These are useful parts of the four walls of your investment picture, but they're supposed to go together. Any one area can change. In financial planning and in the history of investing, we have learned that the only certainty you're going to get is the guarantee of uncertainty. Things keep changing. Maybe there's a perfect mathematical equation that says you want this much in real estate, this much in a taxable account, which we can explain to as many different types of accounts. And maybe you want something in a retirement account, a tax shelter account, or an after-tax account. These are the conversations that we dig into. And then we help you fill up these buckets. Keep it in your estate plan so that it can best serve your use and needs. Because again, it's going to change over time. I had a conversation with someone just recently who was talking about saving for retirement. They're younger and they want to have access to a retirement account. The question, though, was do you want to pay the taxes on that money now when you're early in your investing career, you're early in your professional career, so you might be at a lower tax bracket? Or do you want to pay the taxes later when you don't have to worry about an income stream from employment? These are the sort of conversations that we have. The answer to this particular client may have been, let's pay the taxes now. And that's where we would talk about something like a Roth IRA. Roth means an after-tax contribution to an individual retirement account. Or maybe you want that in your 401k if your employer offers it. We help explain what this means and the value that it offers. One quick note about concentration risk as well. We will dive into this, and we take great pride in our relationship with the estate planning and advanced planning teams at Copenbarger to best understand what your asset is, and then we're best able to help you get away from the concentration. We do not just off of the bat say, you're overly concentrated in a stock, sell it. Why would we do that? We wouldn't, because it might trigger a taxable event. Maybe there's a better way to use that stock as a resource. Maybe it's offering a dividend that we can then diversify out of, or you can create a borrowing structure to fund part of your estate plan or to help bridge a certain short-term financial need that will not create a taxable event for your estate. These are the conversations that we end up spending most of our time with clients when we get started. Or if you have a plan and maybe you didn't know about these options, that's no fault of anyone's because you need to be exposed to this understanding to then see what the options are to be available. Again, we try to educate people probably more than anything else that we do. Life changes, so we need to update things where appropriate. As I said, your estate plan should get updated, checked, take it out of your bookshelf more than once every 5 years. Go to the law offices of Copenhagen, talk to Victoria, make sure that the estate tax or estate planning laws are not changing from underneath you. The financial components of your estate plan will change yearly. We have a lot of changes in the works, and they do lead to legal and tax changes, but the financial landscape is changing all the time. One of the things that we talk about a lot, and Victoria mentioned this earlier, is banks. Banks or credit unions require proper titling. We will tell you if you're proper titling your stuff from an investment perspective, which is different than the estate planning perspective, but we need to draw it back into your estate plan to make sure everything is in good order. We touch on this because these build your liquid investments. When I talk about liquid or illiquid, I might be talking about real estate versus stock and bonds. All of it creates the financial picture. I tell people too often, if you just look at one of these things, you're not going to have the opportunity to look at the full picture and how they relate to each other. You want a balancing act, and as your estate plan grows, your financial resources will probably grow as well over time. You'll want to have retirement assets. Within retirement assets, it might be pre-tax or after-tax contributions, and there are really legitimate reasons for both types of structures of retirement accounts, depending on where you are in your financial plan path. Non-retirement assets, which might even become larger than retirement assets, could include real estate or illiquid assets. Maybe there's commodities. Maybe there's gold coins that you have shoved under the living room rug. I don't know. Or underneath the doghouse outside in the backyard. That's part of your financial plan. Should also be definitely included in your estate plan. Or you have investment accounts. Maybe over time you've gone from one employer to another to another. That happens regularly. Have you consolidated your retirement accounts? Have you explored the best options to consolidate them? Non-retirement assets. Have you considered the various investment structures to be put into? Sometimes it's appropriate, and we have licenses and trainings to understand annuities or life insurance that may or may not be appropriate, but it's worth talking about because no stone should be left unturned when it comes to the importance of your financial plan. Sectors of investing. Sometimes one area of the investable landscape might be doing better than others, but that doesn't mean you can just not look at one area. For many years, there were areas of technology that were not profitable. Now they are incredibly profitable. It's not as simple as just looking at technology or financials or real estate or energy. It's balancing what's actually underneath the hood of those terms and placing the appropriate amount of value or dollars there to grow to meet the goals that you're trying to achieve. Or if you've already built something, preserving that value and having it work for you or the next generations. Or if you're trying to structure something, say you want to fund a foundation, having the right sort of investments fund that foundation within your estate plan, and they have the right financial team that can speak intelligently towards that investment strategy. Because that foundation strategy might be different than your personal strategy, but they do relate to each other. I recently had a meeting with a family who I have known for a very long time, and they are very close to me personally. I have understood that they have accumulated a value in both real estate and investments. They spend a lot of time trying to figure out how to structure things for their charitable giving and for their family. And they've spent years planning this, and a lot of it made some really good sense. I had a meeting with some of the attorneys at Kopenbarger with these clients and myself because we discovered a few things that they didn't think about. Some of the sectors of their financial plan were not in this original plan. And so we take a look under the hood, we put it all together in front of them, and then we tell them, maybe you should consider this because of these reasons. That's the value of looking at the entire financial picture, relating it back to your estate plan, and then having a team not only build the four walls of the document, but constantly be with you or be in the trenches, sometimes I say, to grow and advise and keep the plan on track. So what would I say to take away from this? Well, first, please make a plan. If you don't have a trust or a will with Victoria, she will take very good care of you or any of the attorneys at Kopenbarger. Because in this day and age, not only because of a more litigious nature or the changing landscape daily, we are in a situation where you need the planning more and more and more. I would also say you need a financial plan, even if it's just a gut check. One step further. Make sure that all this relates in a tax efficient way to your household. Don't just think that because it might not be appropriate for you right now, it might not become appropriate for you in the future. Everybody has a plan, and then they get a gut check, and then you want to make a few changes here or there. It's good to have trusted counsel and advisors who have seen things before, experienced things, and will create the right sort of space to have the candid conversation to help navigate towards the best plan. Worst case scenario, you already have a plan and you just spend some time with me or Victoria to reassure that you're in a good position. That doesn't sound too bad to me at all. Understanding what you're invested in. I have seen a lot of investment structures, a lot of accounts where people say, "Oh, I know I'm invested in something and it grows." That's great. It's really good to at least know what you're invested in. And I would always ask the open-ended question, can you please tell me a little bit about what you're invested in? There's no right or wrong answer, but being quiet, I would advocate, is not the best way to have that conversation. Don't just set it and forget it. Set it with a responsible team and know that you don't have to see it day to day because professionals are monitoring it for you. As an attendee of this webinar, you get a free consultation with Lifestyle Financial. I am a very friendly person and look forward to speaking with people often. And I thank you for the time, and I thank the law offices of Kopenbarger and Kopenbarger for such a great relationship. And I get the chance to work with Victoria. I've seen firsthand how much she cares about every client who comes across her table. I cannot tell you, seeing a lot of other estate planning attorneys, how much the Kopenbarger family takes care of their clients. And we try to do that to the best of our abilities as well at Lifestyle because it is a family that helps families.
Thank you so much. All right. Get there. Great. Well, thank you guys for joining us. We really appreciate it. I know that time is valuable for so many people, and we very much appreciate that you took some time out of your day to be here. I know it may sound weird when we're in talking about love and everything else to talk about what happens when you die. Not many people could put love and what happens when you pass away together. But the reality is planning ahead, making sure that your estate plan is in place, making sure that your financial strategy is in place, making sure that those you care about are left with as comprehensive set of guidelines as possible is a very large form of love and a way to say, hey, I want to make sure you are still taken care of, even if I'm no longer here. So, as Zach mentioned, please come and speak with us if you have any further questions, if there's anything that you are confused about or know you need to make changes for, or you're just interested in getting a comprehensive overview of your plan, both financial and estate planning. So we are here to assist. We very much, again, thank you for taking time out of your day to watch this webinar and be here with us. If you have any further questions, please feel free to put them in the chat or the Q&A. We will hang out after for a bit to make sure that those get answered. We will also ask you to fill out a survey letting us know how we did today. That feedback really helps us know, did we capture what you guys were looking for? Is there anything different you would have liked to have seen? And lets us get that feedback so that these webinars continue to be helpful for you specifically. So thank you very much. Like I said, we'll hang out and answer any other questions that come in. Otherwise, I hope the rest of your day goes very well.